Start. Heard, learned counsel for the petitioner and learned additional chief standing counsel appearing for the state respondents, full stop para. By means of the present petition, the petitioner being aggrieved with the transfer order dated 31/5/2018, a copy of which is annexure 2 to the writ petition transferring him from Siddharth Nagar to Kushinagar, as well as aggrieved against the order dated 30/8/2018 by which the representation of the petitioner has been rejected, is before this court, full stop para. It is argued by learned counsel for the petitioner that initially wide order dated 31/5/2018, the petitioner, who was working as senior assistant and had been transferred from Siddharth Nagar to Kushinagar, full stop, being aggrieved with the said order, the petitioner had approached this court by filing writ petition number 22234 in bracket SS of 2018 in relation Krishna Kumar Gupta versus State of UP and others, which was disposed by this court wide order dated 6/8/2018 by directing the respondents to decide the pending representation of the petitioner, full stop para. In pursuance thereof, the respondents have proceeded to pass the order dated 30/8/2018 by which the representation of the petitioner has been rejected, full stop. While rejecting the representation of the petitioner, it has been contended by the respondents that petitioner has been working in district Siddharth Nagar since the last 25 years, full stop. It is also contended that the petitioner along with his wife is an impediment in the working of the hospital in as much as repeated queries under the Right to Information Act are raised by the petitioner and his wife, which amount to 85 in number. Consequently, taking these facts into consideration, it was decided to transfer the petitioner to some other district and institute disciplinary proceedings also against him, full stop. Thus, learned counsel for the petitioner submits that the impugned order rejecting the representation indicates that the petitioner has been transferred on a punitive basis, which order cannot be sustained, full stop. It is also argued that the petitioner has been posted in district Siddharth Nagar since February 1999 and not since the last 25 years as indicated in the impugned rejection order, and thus it is contended that the impugned rejection order indicates patent non-application of mind to the relevant facts of the case and has been passed in a prejudicial manner, full stop. It is also contended that upon the representation of the petitioner, report has also been requisitioned from the Chief Medical Officer, Siddharth Nagar, and without even waiting for the report, the respondents have proceeded to reject the representation of the petitioner, full stop. Thus, it is argued that both the impugned transfer order dated 31/5/2018 and the rejection order dated 30/8/2018 are patently bad in the eyes of law and merits to be quashed, full stop para. On the other hand, learned additional chief standing counsel on the basis of instructions has produced a complaint dated 24/4/2018 sent by the Dr. Rochis Mati Pandey, Chief Medical Superintendent Siddharth Nagar, to the Chief Medical Officer Siddharth Nagar that she is the sole lady gynecologist working in the hospital and repeated queries under the Right to Information Act are being raised by the petitioner and his wife with an intention to create an impediment in the working of the hospital, full stop. It is also indicated in the complaint that in the capacity of being the sole lady gynecologist, there is heavy pressure of patients and sometimes there is some delay in submitting the reply to the said RTI queries, with the result that the petitioner and his wife take up the matter before the State Commission and repeated warning etc. are being issued by the State Commission in the appeals being preferred by the petitioner and his wife, and as such it has become next to impossible to work and carry out the patient duties on account of the repeated harassment on the part of the petitioner and his wife through the unnecessary RTI queries which also do not have any basis. Full stop. It is also argued by the learned additional chief standing counsel that transfer is an exigency of service and a person cannot be permitted to either choose a particular post or a particular district for his posting, and transfer order can be interfered with only on certain legal grounds which have not been set forth in the instant writ petition. Full stop. Para. Having considered the arguments of the learned counsel for the contesting parties and perused the record, what this court finds is that it is an admitted fact that the petitioner has been posted since February 1999 at Siddharth Nagar, if not since last 25 years. Full stop. It is a settled proposition of law that transfer is an exigency of service and it is the prerogative of the employer to transfer the employee to any place where the employer himself feels that the petitioner would be able to discharge the duties and shoulder the responsibilities of the post to which he is being transferred in an effective manner. Full stop. Para. In this regard, this court may refer to the following judgments. Full stop. Para. The Honorable Supreme Court in the case of Rajendra Roy versus Union of India in bracket 1993 1 SCC 148 has held as under. Full stop. Para. It is true that the order of transfer often causes a lot of difficulties and dislocation in the family setup of the concerned employees, but on that score the order of transfer is not liable to be struck down. Full stop. Over.